Namaste everyone. Welcome to Courts This Week on LiveLaw. I am Taniya Pandey, and every week we bring updates regarding the most recent judgments and orders delivered in various courts across India. To stay updated, subscribe to LiveLaw and click the bell icon to not miss any videos from us. We'll begin the episode with judgments from the Supreme Court. The Supreme Court on 21st April extended until further orders the status quo order against the demolition drive launched by the North Delhi Municipal Corporation in the rioted Jahangirpuri area. A bench of Justices L. Nageshwar Rao and B. R. Gavai issued notice to the NDMC in the petition and sought its counter affidavit within 2 weeks. We'll take serious view of demolition that took place after information was given to the mayor, the bench observed during the hearing. Notably, a bench led by the Chief Justice of India had ordered status quo on demolitions until further orders on 20th April after an urgent mention was made by Senior Advocate Taniya Pandey. The Supreme Court on 18th April set aside the Allahabad High Court order granting bail to Ashish Mishra, son of Union Minister Ajay Mishra, in the Lakhimpur Kheri violence case, holding that the High Court passed the order taking into account irrelevant considerations and denying the right of hearing to the victim. The bench of CJI N.V. Ramana and Justices Suryakant and Hema Kohli set aside the bail order and asked Mishra to surrender within a week. The bail application has been remanded back to the High Court for fresh decision on merits after taking note of relevant considerations and after affording right of hearing to the victim. The Supreme Court has observed that a presiding officer of a sentencing court, while giving opinion on a remission application, should give adequate reasons. Inadequate reasons, in the opinion of the presiding officer of the sentencing court, would not satisfy the requirements of Section 432, subsection 2 of the Code of Criminal Procedure. The bench of Justices D.Y. Chandrachud and Anirudh Bose observed. The court observed that the purpose of Section 432(2) CIRPC is to enable the executive to make an informed decision, taking into consideration all the relevant factors. The Supreme Court has held that insider trading cannot be presumed merely on the basis of proximity between the parties. The bench of Justices Vineet Saran and Anirudh Bose held communication of unpublished price-sensitive information under Regulation 3(1) of the SEBI Prohibition of Insider Trading Regulations 2015 ought to be proved by producing cogent materials like letters, emails, witnesses, etc., and not be deemed owing to the alleged proximity between the parties. The court further held that the onus is on the SEBI to prove such communication. The Supreme Court has observed that merely because doctors could not save the patient, he or she cannot be held liable for medical negligence. Doctors are expected to take reasonable care, but no professional can assure that the patient will come back home after overcoming the crisis, the bench of Justices Ajay Rastogi and Abhay S. Oka observed. The court added that the liability would arise only if either a person, that is a doctor, did not possess the requisite skills which he professed to have possessed, or he did not exercise with reasonable competence in the given case the skill which he did possess. The Supreme Court has held that the dues towards the wages or salaries of only those workmen or employees who actually work during the corporate insolvency resolution process, CIRP, are to be included in the CIRP costs. The court clarified that the wages and salaries of all other workmen or employees of the corporate debtor during the CIRP who actually have not worked and or performed their duties when the corporate debtor was a going concern shall not be included automatically in the CIRP costs. Such dues will be governed by Section 53(1)(b) and Section 53(1)(c) of the Insolvency and Bankruptcy Code, the bench of Justices Hema Shah and Anirudh Bose observed. Let us now go over important judgments from different high courts and other courts. Noting that certain observations by the trial judge about the rape victim's conduct need to be revisited, the Bombay High Court's Goa bench granted leave to the state of Goa to appeal against the order acquitting Tarun Tejpal in a 2013 sexual harassment case. The court rejected Tejpal's preliminary objections against the state's leave to appeal. A division bench of Justice M.S. Sona and R.N. Lagha also observed that inferences against the victim regarding legal consultation also needed to be looked into. The Delhi High Court has granted an ex parte ad interim injunction in a trademark infringement suit filed by news channel Aaj Tak, a part of India Today Group, against Aaj Tak Gurgaon. Justice Jyoti Singh restrained the defendants from using the trademark Aaj Tak in relation to any goods or services, including their print, digital newspaper, publication, website, social media and content sharing platforms, including Facebook, Twitter, YouTube, Instagram, LinkedIn, and any other location on the internet till the next date of hearing. The court also directed that the domain name registration of the impugned domain name aajtakgurgaon.com be suspended. The Punjab and Haryana High Court has reiterated that anticipatory bail plea on behalf of a proclaimed offender is not maintainable. The bench of Justice Judge Gurpreet Singh Puri was dealing with a petition filed under Section 438 CIRPC for grant of anticipatory bail in an FIR registered under Section 174 A IPC, wherein the petitioner was declared as a proclaimed offender. The court noted that the petitioner remains a proclaimed offender till date, and he did not challenge the order that declared him a proclaimed offender. In relief to Britannia, which runs the product range Good Day Butter Cookies, the Delhi High Court has directed Parle Biscuits to take down 2 of its advertisements disparaging Britannia's products. Justice Pratibha M. Singh directed Parle to ensure that it modifies the ads within 2 weeks by blurring the image of cookies displayed by them, which is similar to those sold and marketed by Britannia. It was the case of the plaintiff that defendants seek to promote their product, Parle 2020 cookies, by denigrating, defaming, and disparaging the plaintiff's Britannia Good Day Butter Cookies or Good Day range of cookies. The Kerala High Court has held that the courts in India cannot entertain any request directly from any private parties or institutions to initiate proceedings for attachment of properties in foreign states, and added that such requests can only be made by the centre or appropriate authorities under Section 105 of the Code of Criminal Procedure. Upon examining the legislative intent behind incorporating Chapter 7A of CRPC, Justice Ziad Rahman AA took the stand that permitting any individual or establishment to file an application would amount to reading into the provision something which was never intended to be contemplated therein. The National Company Law Tribunal Mumbai bench, comprising of judicial members Srimati Suchitra Kanukarthi and technical member Srimati Anuradha Sanjay Bhatia, has issued notice to City Networks Limited by order dated 30th March 2022. HDFC, which was the financial creditor, had filed a petition under Section 7 of the Insolvency and Bankruptcy Code 2016, seeking initiation of corporate insolvency resolution process against City Networks Limited, which was the corporate debtor, for an alleged default of approximately Rs 296 crores in respect of the financial facility granted by the financial creditor. Notice was issued to the corporate debtor with the liberty to file a reply. With this, we've come to the end of today's episode. Thank you for joining us. I'm Taniya Pandey for LiveLaw, and you're watching Courts This Week. Have a lovely week ahead.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.